each chargeback has a different reason, as I stated earlier, or different reasons cited. And while there can be a lot of repetition of dealing with the same types of chargeback disputes over and over again, it is important to make sure that you're tailoring your response to the chargeback reason. So if the reason given is that the client didn't authorize the charge, then what you're having to prove is that the person that you gave your legal services to and who paid your firm, that they actually authorized the card that was used. And so that then you're looking to see, was a third party involved, et cetera. We've seen in the past, in some cases, firms will have sort of a default templated response to chargebacks. It might work some of the time, but adjusting depending on the reason code and making sure that you have the right evidence to actually address the claim that's being made is important.
Welcome to another episode of Financially Legal, the podcast for law firm CFOs. I'm your host, Emery Wager, co-founder of Confido Legal, an embedded payments platform specifically designed for the legal space. Today we've got a great episode for you. I got to interview Amos Chapman, one of my colleagues, who has helped hundreds of law firms manage chargeback disputes. A chargeback dispute is when a credit card transaction initially goes through, the money is deposited into your law firm's bank account, and then it's later reversed, and that can happen for a variety of reasons. Chargebacks can be daunting, they can be scary, and they can create financial risk for your firm. Amos does a great job going through what a chargeback is, best practices, and I think this episode will be very valuable for our listeners. Amos, very excited for this episode. We are going to seriously nerd out on some very specific payments related issues for law firms. So this may be too deep for every law firm, but especially if you're an accountant or you're at a larger firm where you're doing high volume transactions, this is definitely an episode that can help you save money, retain that money, and reduce all the headaches associated with chargebacks. Let's start from the beginning. What the heck is a chargeback?
That's a great question. So a chargeback is a dispute that's initiated by a payer in its most basic definition. In the case of law firms, a chargeback would come in the form of a client contacting their bank to dispute a payment that they made to the firm on the basis that it was invalid for any number of reasons. And each chargeback comes with a different reason given for why the payer is claiming that the dispute, but that the payment needs to be disputed.
Got it. And there's a bunch of reasons you could receive a chargeback, fraud, that kind of thing. But today, I think we're going to focus most on the most common type of chargeback where, like you said, the client, calls up their bank and either says, I didn't receive these services, or the services weren't as expected. That's kind of the most common scenario, correct?
Certainly the most common form. Yes, every once in a while there's different scenarios where fraud is clearly involved, but that's the most common form.
Okay. So let's say a client, calls up their bank and says, I didn't get the representation that I was promised, and I'd like to charge this back. What happens next?
So what happens next is that a case is filed, and there is a portal that we navigate on behalf of our clients, where essentially all of the information is posted about the dispute, and there's a summary that's given that allows the firm to identify who the client is and what the payment was. And then there's a deadline given for a response. And then the firm at that point has the option to submit a response to address the claims that are made in the chargeback details, or they can just accept the dispute, which in essence means that they just accept refunding the payment along with a $25 fee that is always charged regardless of the outcome.
Talk a little bit about sort of who's managing this process. Is it
A lot of people, because it's the payment processor who deducts the money, think that it's the payment processor who is kind of evaluating this or managing the dispute process, which is incorrect. So how is this process being run? Kind of who's managing the chargeback process?
That's a great question. So you're right that in many cases the perception is that it is the payment processor. However, your payment processor may have some services where they serve as sort of the middleman communicating about a chargeback case. But in reality, the cases are filed by the bank that issued the card that was used by the client. So the card issuing bank, all of the banks together have a sort of network where these cases are submitted and reviewed. And they're governed by the rules, which are different for each card brand. So a chargeback from Visa versus MasterCard has some different rules and different deadlines involved. But the card brands and the card issuing bank, those are the parties who are actually mediating these disputes.
The consumer files the chargeback regardless of the eventual outcome or the merit of that money gets taken back no matter what right away. Is that right?
Yeah, correct. So to clarify, uh, the first step when a chargeback dispute is initiated is for the funds to immediately be withdrawn from the business's account and credited to the client, credited back to the payer. Now that happens right away, regardless of whether the claim they're making is veracious or correct, regardless of what happens ultimately with the chargeback. So if a firm is responding to argue against a chargeback, they're essentially trying to get their funds returned to their account. And if they're not successful, they never recover them. And there's a fee to the business each time, regardless.
If I'm hearing you right, you could be a law firm that does everything right. Maybe you do something on flat fee. Let's say you're doing, you're setting up an LLC for somebody on a flat fee service where they're paying up front for that service. You get the engagement agreement. You do all the things that we'll talk about
Right.
down the road about how to really tighten up that process and give you the best chance of winning the chargeback. You do everything right, and that client issues a chargeback, and you're still going to get that initial debit no matter what.
Exactly. It could be through no error or on the part of the firm. Even if I've even seen cases where we've had firms who are working with a client who is in a financially challenged position, and they have done extra work for them at no cost, and gone out of their way to provide services beyond the actual payment that the client made. And still, the client contacted their bank later to dispute the payment, and it was automatically withdrawn from the firm's account. So it can happen, and when it doesn't on its own speak to any faults necessarily. It could just be someone trying to exploit the system to get their money back.
Okay, so the chargeback has happened. The money's been deducted. You get some notice. So in general, kind of what's next from there? What's the next step in the process?
It's a great question. So the next step is to sort of review the summary of the chargeback, which will include, each one is assigned a case number. So if you have several disputes, you can refer to the case number as a way to track the right one. And it will have a summary of the details, the date of the original payment, the last four digits of the card that was used, the amount, the bank account it was paid into. All of that should be enough to help you locate this payment and figure out who the client was. They don't actually reveal in those summary documents the full name of their account holder, the bank that is. So they give a lot of the other details, but they leave it up to the firm to ID the person. So at that point, you have to look through the history to figure out what payment this was and who it was from. And I think the way most firms approach chargebacks at a high level is just looking at the amount to see if spending further time on submitting a response is worth it. If it's under $100 or if it's a smaller amount, it might not justify the amount of time it would take to submit a response, and you can just accept the refund. But if it's a larger amount, then it might merit more investigation.
Got it. And a client who could have just called up and asked for a refund, oftentimes you'll see them just initiate a chargeback because for some reason they think that's easier than calling up, their law firm for to ask for a legitimate refund. Is that fair to say?
Yeah, absolutely. It's definitely fair to say. And the interesting thing about that is that even in cases where they did request a refund and it was already sent, they can still dispute the payment. And in some cases, the card issuing bank will still allow the original payment to be disputed despite the fact that there's a refund to that same card and it's in their records, but it's still incumbent on the firm to point that out and to pull the right reference information for the refund to prove that they did it. So absolutely, yeah, that can definitely occur.
Let's kind of sit there for a second and really dig into that. So if you get a chargeback, oftentimes a knee-jerk reaction would be to send a refund to fix it.
Right.
You really don't want to do that because, like we said earlier, the funds have already been deducted, and if you run a refund, you're basically going to send that money back to the client twice.
Exactly. Yeah, that's often the first instinct, and it's understandable. And it's, even in cases where one of the types of chargebacks is a claim that the payment wasn't authorized. So usually what that means is that the payer is claiming that someone else used their card. They didn't authorize the payment. It was used without their consent. And in some cases, if you suspect that that's the case, your instinct might be, well, to just, send the refund. But you should always avoid that and just know that they have already been refunded. So if you do want to honor the refund, then you can accept the chargeback, but anything additional would duplicate it. And in some cases, even if you have issued a refund, it doesn't guarantee, even if you prove it, that you will get the original chargeback, disputed amount back. So in general, just best to avoid that in pretty much all cases.
It's sort of like litigation. You could have the best case in the world. There's always a chance that you'll lose. And that's super important to keep in mind, that it is just a risk of accepting this payment method. We have a great resource at Confido called the Chargeback Checklist that we'll link to in the show notes so you can download it. And this goes over everything that you would need to dispute a chargeback, whether you're working with us or any other payment processor. Amos, talk a little bit about what are some of the key things on that chargeback checklist? Like when they get the dispute, what should firms think about submitting?
That's a great question. So the first thing that I would say is on that list, and it's there's some technical things to check to make sure that you're responding to a chargeback correctly, and we can go over those. But the first thing I would say on the list is more of a general recommendation to approach the chargeback like a law firm. So one thing that we've realized is that law firms in many cases will leave the management of chargeback cases to their billing admin, which is understandable and usually how that's handled. But as a result, the strengths sort of inherent in being an attorney or being a law firm are sometimes not used, even though these chargebacks are essentially a version of litigation, as you said earlier. So specifically what I mean when I say think like a law firm is drafting a summary letter. It is an important step in putting together a chargeback response. If you think that someone is disputing a payment on false grounds and you have documented the work that you did for them, then an attorney writing out the summary of that and signing it on their firm letterhead really goes a long way. And it makes sense because the card issuing bank who is putting forward this dispute is just taking their account holder at their word that they were charged improperly. But as soon as they see a sort of thought out response from the law firm, I think it can really go a long way toward leading those disputes to be closed. We've seen that very often. And also, they don't necessarily understand that you're a law firm. So these chargeback disputes happen for all different types of services. And often they're dealing with disputes related to merchandise that wasn't received, that was bought at a physical store, for example. And so it's important to identify yourself as a law firm and explain a little bit about the intangible services that you provide, because while that can be a little bit of a disadvantage in chargeback situations, the fact that legal services are not something that you can as tangibly prove or delivered in many cases. I think being a law firm in these situations itself can be a huge advantage. So identifying that and writing a summary letter that really reflects that on firm letterhead, we've seen that be a really effective element of responding to these cases.
Yep. And to extend on that a little bit, realizing that when you are submitting this documentation, you're presenting it to people who have probably very little idea how a law firm operates. They're dealing with airlines, magazine subscriptions, retail, and you as a law firm are a very small percentage of the traffic that the folks managing this process and reviewing these get. So I think that's a really important point to make sure to communicate from the 101 level how a law firm operates.
Yeah, absolutely. I think that I found in working with firms when I first got into helping to manage chargebacks that we were thinking about how to respond in a kind of A to B way, assuming that the person reviewing the response had more context than they likely had, and add to the fact, as you said, they're reviewing on a daily basis tons of these different disputes across all different kinds of industries, and legal services has a much lower rate of chargebacks compared to a lot of other airlines and subscriptions and other. So they probably don't come across these very often. And when they do, you shouldn't take it for granted that they understand at all that this is a law firm, what type of services they provide, et cetera. So sometimes starting there is a really good place.
All right, Amos, let's rattle it off. Like, what are the things that a firm should submit when they get a chargeback?
So I mentioned the summary letter. That's the first thing, just a single page letter explaining why you're entitled to the funds that were paid and they shouldn't be given back to the payer. After that, the other pieces really depend on what type of chargeback you're dealing with. One of the most common types of chargebacks is merchant services not received, which essentially means the payer is claiming, hey, I gave this firm money for legal services and I never got them. And law firms can be a little bit vulnerable to that because a disgruntled client who is seeking legal services at a divorce firm, for example, could be unhappy with the outcome of their divorce proceedings, and then they could contact their bank and say, I'm not satisfied, I didn't get the services I received. That's one of the more common forms. So when that's the case, the thing that you're being asked to prove is that you provided the services that were paid for. And that can be easy to do if you already have the right pieces in place. So one of the pieces that's really important to that is having a signed service or engagement agreement upfront with the name of the payer clearly printed and then signed and dated, stating that they understand what services they are going to receive, how much they're going to cost, what the payment terms are, et cetera. And then another important element to that paper trail is going to be invoices showing that whether it was hourly work or specific flat fee legal services, showing the specific work that was done and how it was documented for the client. And then if you completed a court filing or there was something specific that you did for this person, that you can show receipt of, also including that to sort of show your work. Those are the important pieces. And assuming that they are all kind of clearly visible and well documented in a response, that would be sufficient in most cases to have those funds recovered. And also, less is often more. People, I think, tend to compile large documents in response, but in reality, these are mostly skimmed through from everything we know for relevant information. So just putting together a short response highlighting the relevant pieces of the billing that you need to demonstrate would be the general kind of strategy there.
Let's say you don't have an invoice, but you've had some back and forth over email. Maybe submitting, some of that email communication can be helpful. Do keep in mind though that although this does stay in the chargeback system, you have to be careful about disclosing client information because it is it's you can't really control where this information is going to go. So keeping that in mind when you're submitting that information, and making sure you're maintaining a level of confidentiality while still disputing the chargeback. So that can be kind of a tough line to walk.
It can be challenging to walk that line in a way that fully complies with client confidentiality. I think the rule of thumb there is that you can redact anything that's not relevant, and sometimes that can actually help you to direct the attention of whoever's looking at this response to what's most important. We've realized over time that winnowing down to the most important parts is also an effective element of responding with, in a way that will lead to an approval. Sometimes I think the instinct is to overwhelm just with a lot of files, and while that can sometimes work, I think more often than not, it gives them a reason to decline the response because it was sort of too dense for them to find what was most relevant.
Talk about the situation. We see this a lot in family law, immigration, even some of the B2B practice areas where the engagement agreement might be with someone different than the person whose name is on that transaction.
Yeah.
Talk about that situation. What can a law firm do to avoid losing a chargeback simply because those names didn't match?
Yeah, absolutely. So the best way to avoid that is by getting in front of it, or getting ahead of it rather. And the most effective method is to incorporate, where needed, a third-party payer agreement into your initial paperwork with your client. And that requires checking ahead of time to see if your clients are going to be relying on a spouse or a family member to make payment. But if you can communicate about that, then you can draft an addendum or an additional agreement where you can collect a signature from whoever the third party is who's going to be making the payments, signifying that they are authorizing payments as the third party. And those are really important and often get overlooked. I think with the convenience of accepting credit and debit cards, law firms don't often consider the fact that if they are collecting payment via a credit card from a client, that client could just be using the credit card of a family member or a friend or a different payer. So it can happen easily, but when it does create a lot of vulnerability to a chargeback dispute, because if there's a falling out between the person who gave their card to your client at any point, then they can go to their bank and dispute the payment, say, I didn't authorize this. And unless you have something connecting them to the client, the person who received your services, then you won't actually be able to win any of those disputes. So collecting their signature early on is going to be an important part of the process.
Yeah. And in addition to the things that you have access to submitting, there's also some kind of technical payment processing evidence that you want to be able to submit. Ideally, your payment processor is just has this information ready to go and can submit it for you.
Right.
But if that's not the case, talk about kind of the technical things that you'd want to submit with a chargeback.
Yeah, that's a great point. So the case number does help to give you a number that you can reference to identify the case, so that you're not having to pull as many of the technical details. But in general, the details that they're going to look for are the name of the payer and the client, or if they're different people, their names, the date that the payment was made, the last four digits of the card that was used, the brand, and a lot of that information is going to be included in the chargeback packet itself. There are cases where, for example, you need to prove that you issued a refund. There might be a technical number, an authorization number, for example, that you would need to source, or a transaction ID. And in those cases, I think it's pretty inevitable that you're going to have to interface with a vendor, depending on your setup. But for the most part, you can get the technical details that you need about the transaction from the chargeback itself, which will contain all of that in the summary.
Got it. And also, if I'm remembering right, a receipt, like a copy of a receipt, is helpful and sometimes required.
Yes, the receipt, certainly a copy of the receipt that you can include in the response. And most responses are compiled as PDFs, and that's typically the simplest way to put everything together. So you have a summary letter, your invoice, or screenshots of your email communication with the client, whatever the key pieces of evidence are, included there as well, and then the payment receipt that was sent to the client. Those are usually, at a minimum, the important elements to include. And it's also, I think, another important thing to keep in mind is that each chargeback has a different reason, as I stated earlier. There are different reasons cited, and while there can be a lot of repetition of dealing with the same types of chargeback disputes over and over again, it is important to make sure that you're tailoring your response to the chargeback reason. So if the reason given is that the client didn't authorize the charge, then what you're having to prove is that the person that you gave your legal services to and who paid your firm, that they actually authorized the card that was used. And so that then you're looking to see, was a third party involved, et cetera. So we've seen in the past, in some cases, firms will have sort of a default templated response to chargebacks. It might work some of the time, but adjusting depending on the reason code and making sure that you have the right evidence to actually address the claim that's being made is important.
Awesome. I want to go back to the refund real quick. There's kind of a general rumor that if you process a transaction, a client asks for a refund, and instead of refunding back on that card, you say you send them a check, and then they dispute the original transaction on the card. Is that sort of automatically lost, or how does that?
It might not be automatically lost, but there's a good chance it will be. So as a best practice to protect yourself against chargebacks, it's very important anytime you can, to send refunds to the payment method that was used for the original payment. So if a payment was made with a credit or debit card, refunding directly to that card, as opposed to cutting a check for a partial refund. I think in legal, where we see this most commonly is when a partial refund is being sent at the end of engagement for whatever funds are left in trust. It's very standard to write a check for that amount. But if the original payment into trust was made with a credit card, the issue there is that even if you prove that you wrote the check to the client, and even if you have the check tracing details and you can prove that it was cashed, that still does not guarantee that you will win the chargeback. And so the client could have a duplicate refund. They could take the check that you sent them and deposit it, and they could have the funds returned because of the dispute. We've actually seen this happen before. So then the reason for that is because the card issuing bank who is who put the dispute in place, they're not involved whatsoever with the issuing or tracking of the check. And so if it's Visa or MasterCard, for example, showing them that you sent a check to the client on its own is actually pretty unlikely to lead them to decide in your favor, because that's not their domain.
Yeah. So it's not an automatic loss, but certainly not a best practice to do
Yeah,
that, especially with clients that you maybe don't have a high degree of trust with.
certainly. If there's a high degree of trust, then that's a different situation. You can still win by proving a check refund was issued, but yeah, as the cautious approach, the best practice is to always send the refund to the card.
How long do clients have after the transaction has gone through to issue a chargeback?
120 days. So 120 days from the time the payment was originally made.
What are some of the stories that you're most proud of? Things that you've submitted or helped firms submit that has ended up saving the day for the firm?
Yeah, I got it. We have a few of those. So there was one firm that I was working with, who they provide legal services for clients who are getting evicted, and they just need help filing an extension in court, for example. These are people in desperate situations, not much money on hand, and so the legal services are flat fee, and affordable. But they were dealing with a large number of chargebacks because they would have clients who would sign up for their services, make the $200 payment or whatever it was to get help with a court filing, and then if they didn't like the outcome or they ended up being evicted by their property manager, they would dispute the payment and call their bank. And the firm had just sort of accepted that they were going to get a fair number of disputes, more than the average law firm, and they, in previous years, had just written them off as a loss at the end of each year. And so we worked on kind of a strategy to respond more effectively to these chargebacks, and I recommended, in general, some changes they could make to the structure of their agreements, and how to have a third-party payer agreement in place, because a lot of the chargebacks were coming from situations where someone was having a spouse or a parent make the payment to the firm for them. So we worked on making these changes together, and we saw a really big improvement over time. So we're now to the point where, over 90% of the chargebacks that the firm responds to, they're winning. Now, there are some chargebacks, just given the number that come through, that are not worth the time spent to respond to and to fight. So you have some of those that are just accepted and go through. But in cases where we do respond 90% of the time, at least over the past 3 months, we're getting a pretty quick decision in favor of the firm, because we've gotten to the point where they have the right evidence in place, the right signatures, and because most of these disputes are the same, it's quick to assemble those pieces and submit a response. So it's been rewarding to help bring them from a time when they had just accepted thousands of dollars in a write-off every year, to a place now where losing a chargeback is the exception, as opposed to the default that they're having to accept.
That's awesome. That's awesome. I remember one that was the team submitted as well, where there was court transcripts where the client told the judge how well the representation had gone and how great the attorney was, and we submitted that along with their subsequent chargeback, which did win. So there's a formula here, but also a little bit of an art and room for creativity outside the norm, as long as you, like you said, you're not sort of inundating the reviewers with unnecessary information. So
yeah, absolutely. I think that if I could add one more to the list, I would say that another instance that is another thing that's been really rewarding is we've actually helped a few firms, and I know that we didn't bring this up in this episode, but we do have some more resources on it for anyone listening. We've helped a few firms navigate through pre-arbitration, which is what happens when a chargeback case is escalated by the payer if they don't like the first round of decision. And the a lot of firms will choose not to go into arbitration because there are potential fees involved, and it's really weighted heavily. The burden of proof is weighted heavily on the firm. But we've had a few cases where we had the winning argument, and so just continuing to advance the winning argument and doing it in a way that was strategic has really paid off, even for some like larger disputed amounts in arbitration, which is can be a scary place to go into for chargebacks, at least from the business's perspective. So that's been rewarding as well.
Yeah, it's super interesting. And probably a good time to mention too that our lawyer listeners will know this, but this is just a process that's set up by the card brands, administered by the card brands. It's not a legal outcome in any way. So if you don't get the outcome that you believe you deserve, there's still legal there are legal avenues you could pursue against the client to get the money back. The chargeback is other than through the card brand rules. It's not kind of binding in that way. So I'm getting way out of my depth as a non-lawyer, but it's important to realize that this system is set up by the card brands and is outside any other kind of avenues you could take. No one wants to sue their client, but if you do lose a chargeback, there's always that avenue as well.
Yeah, people hear that word arbitration, they think, it makes sense that they think of it as a legal process, but yeah, it's really just a second stage. And people, when a case is escalated to that stage of chargeback, there's a lot of warnings about higher fees that can be incurred to discourage the firm from continuing to represent themselves. And it's just another way in which the system is set up to be in favor of the client, the payer.
Yeah. It is, if I'm being very generous, an imperfect system, and that's important to
very
remember. If you're participating in the credit card processing system, you get huge benefits like that kind of immediate authorization, and basically the higher likelihood that client will be able to pay, reduced friction, all of those benefits. But it is a very imperfect system, and the deck is stacked in favor of the consumer. So it is a decision that you're making, as a law firm.
Yeah, absolutely. One of the benefits, that is sort of the other side of the coin to this disadvantage, because I've talked to a few firms who have wondered whether or not they should accept credit cards at all, given the risk of chargebacks. They're such a headache to deal with. And I'm sympathetic to that. I understand it. One of the benefits of using offering credit or debit card payments is that everything is tracked. So even if you do have a client who disputes a payment, it's very easy for the parties involved to pull the complete history of payments they have made via the card to your firm. Unlike checks or some other forms of payment, the history is easy to verify, and so that can be a real advantage in these cases when you are navigating a dispute.
Yeah. Makes sense. Amos, this has been awesome. It's fun to have an internal financially legal episode and chat with someone who I get to work with every day.
I enjoyed it.
Any parting words or any parting words of wisdom or advice for law firms who are either considering accepting payments but are nervous about chargebacks, or maybe they're already accepting payments, digital payments, and what should they be thinking about?
That's a great question. Yeah, if you're thinking about digital payments, accepting digital payments, or whether you already do, and chargebacks are on the brain, I think my advice would just be not to be scared of them. I think it's often a deterrent because people perceive it as being sort of a scary litigation-like process. But the likelihood of being penalized for chargebacks is actually very low. You have to have a really high number as a ratio of your overall billing. And if you have someone in your office who can work on it, or if you have the internal resources to respond to chargebacks as they come through, as a law firm, you're probably really well positioned to defend yourself against these disputes and recover a lot of those funds. So at the end of the day, you're looking at some small fees, but I think that in general, if it's deterring you in any way from embracing digital payments, then it shouldn't be, because you're uniquely positioned to respond to them with a lot of effectiveness.
Awesome. Well, Amos, thanks so much for your time today.
Of course, thanks, Emery.
We drop these financially legal episodes every couple of weeks. You can get the most up-to-date info on financially legal by following Confido Legal on LinkedIn. If you prefer email and blog format, you can go to confidolegal.com/financially legal, and we'll see you next time.